Good morning, everybody. Welcome to the Courtroom Files Live. Getting a little bit of an early start because I already have my eyes on 7 busy courtrooms as they attempt to clear the holiday weekend backlog. Let's start out with Judge McNally.
Please don't say it. We're on YouTube here. Is incorrect. Then tell me why you believe that other than she lied on other things.
For a manager name from
Gotta go a lot louder, a lot closer to the device.
last time when I asked about a manager, who is your manager at your work? She said, I don't have a manager. I asked about her middle name. She said, I don't have a middle name.
You have a middle name, ma'am?
Absolutely, Marie, and they have a copy of my driver's license.
Marie, do you have a copy of your driver's license?
And my social security card. When I applied for the application to rent their property, the reason why we're here.
No.
We don't have a copy of it, Your Honor, or we wouldn't be asking for it.
You're making this difficult. You're making this very difficult. I don't know why you are being like this, acting like you're the victim here. You have the legal obligation to provide them with this documentation. It's not my rule. I don't write these rules. But you're making it very difficult. Now you're talking about how you provided them with a social security card at the time that you signed up for a lease, which was what year?
Last year, 24.
All right, but nothing about this discovery subpoena said if you provided them with these documents at the time that you executed the lease, you don't have to bring them. Did I sign something like that?
No,
Then stop acting like the victim. They're going to get their money.
I understand
They're
that.
going to get their money. Okay? They have the right. If somebody owed me $5,400, I would be pursuing it as well, and so would you, and so would anybody else that's listening. Unless they're trust fund babies. Okay? Now, I don't know what to tell you, except do I have to really babysit this and get everything that you emailed them? Did you email them all this information?
The first 2 discoveries that we had in the last 6 months, yes.
I didn't know that. I don't remember anybody telling me that there was no contact provision. I don't, maybe if I was told that at some point, I certainly don't remember being told that. And I
believe that was in September was the first discovery. And then the second one was 2 weeks ago. And then that's when we had come back from the breakout room and you had asked Mr. Street where Miss Nicole was.
here's, listen to me very carefully. You can provide. Okay? Right? I'm rescheduling this to May the 12th. And I'm gonna make it at 11:15 a.m. Okay? That should give you time to get up, guys, time to get up and get your shirt on, Mr. Stupid. Okay? In the meantime, you can send everything that was sent to you to the civil department. Okay? I want you to email plaintiffs to email everything that was sent to them, to the civil department. Now, where do you want us to send that, Lisa? I mean, Jennifer, jeez. Linda. Where am I
You can
sending?
you can send it to mine at linda@33court.com.
Linda@33court.com. You guys writing that down? Write it down. I expect you to send everything to me, to the civil department
And that's LINDA.
at 33court.com. Send by the 28th. We're rescheduling this to May 12th at 11:15. I will expect that everything contained herein You're gonna bring with you in hard copy this time.
Your Honor, I'm
Yes.
sorry to interrupt, but you are not here on May 12th.
Never mind.
How about May 6th?
That's a Tuesday, right?
Yes, because
We can do May sixth. May sixth at 11:15. I'm gonna expect that everything that they requested in their initial subpoena, that you will bring a hard copy. And this is silly that we can't agree on what was sent. That's what I'm doing. Have a great day. Send everything over that she sent you. And you're going to bring copies of the emails and the attachments that you sent to them.
Okay.
Okay? Let's stop this nonsense. In the meantime, you can, if you choose to, have a writ of garnishment issued for her wages. Okay? That's all I'm gonna say. Everybody
you.
have a wonderful day. I will see you in a couple weeks. Thank you very much.
Your Honor, are you signing the writ today? For the garnishment? Or is that a separate?
I don't sign anything. They're gonna submit it.
I just need to know if I have plenty of windows.
If you want, you can file an installment payment order.
That's what we have for $65.
When was that at?
That was the first hearing. This is the third discovery. This was the first discovery in September.
She stopped making payments on her second payment.
And I made the payments up until October 24th.
Slow down, please. Do I have a installment payment order on this? I don't see that I do. Maybe I do. Linda, is there an installment payment order somewhere?
Let me check, Your Honor.
I entered one on $65 every 2 weeks, starting October 21. You need to file a motion to set aside the installment payment order before you do anything.
We filed that.
When did you file it?
Let's see here, I think it was about 2 months ago because she just stopped making payments and never paid again. She made the first one and stopped.
Did I ever sign an order setting aside the installment payment order, Linda?
I'm checking right now, Your Honor.
Take your time. I mean, this has been going on for quite some time now. I told you September 24th, about at least.
Your Honor, you did. On January 30th, there was an order to set aside the payment order.
So there's no installment payment order in effect, so you can feel free to garnish your wages, okay? And that's it. You got.
All right, well, they figured that out. Good morning once again, everybody. Welcome to the Courtroom Files Live. I'm now up to 11 courtrooms that I'm monitoring already. It is a busy morning, not surprising, coming off the holiday weekend as people clear the backlog. Equally not surprising, Judge Fleischer. He's started a good half an hour earlier than he has been. Let's say good morning to him.
Sure, say yes, Judge. No, Judge. Okay, I speak English, sir. Judge, you like a translator, or do you speak well enough? No, sir. I'm good. All right, Mr. Octaviano, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
On April 11th, 2025, in Harris County, Texas, officers dispatched to a motor vehicle accident. Upon arrival, officers observed an individual standing on the passenger side of the motor vehicle talking to several McDonald's employees. The defendant confirmed to officers that he was driving the motor vehicle that was present. Another officer verified the defendant was driving by talking to witnesses on scene who stated that they observed the defendant exit the motor vehicle from the driver's seat and was the only occupant of the motor vehicle. Let's see. The accident occurred in the 10,100 block of Hammerly Boulevard, Houston, Texas. I'm just trying to get some details on the accident, Your Honor. Officers observed the defendant have trouble maintaining his balance, slurred speech, and drowsy eyes. Defendant initially stated he had nothing to drink, then stated he had Buchanan's, but not too much. Defendant stated he had eaten a torta, but could not remember where it was from. Standard field sobriety checks were conducted with the following results: 6 of 6 HGN, 7 of 8 walk and turn, 3 of 4 one-leg stand. DIC was read. The defendant consented to a breath test. 0.202 and 0.195 were the results.
Who said anything about driving? Did anyone? I
So,
know you have the admission, but
right, and they said there was several witnesses that saw him. I'm checking now to get some details on that actual accident, Your Honor.
but you have witnesses that put him driving.
Yes, Your Honor, there was officers there that saw him.
I don't know if those witnesses are named, Your Honor. I haven't had a chance to look at the offense report.
Well, I'll give you time. This is just a probable cause hearing, you know, if it goes, right. Mr. Octaviano, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
Does he have a valid Texas
does,
license?
Judge.
You cannot drive unless you have a valid Texas driver license and liability insurance in your name. If you do not have car insurance, do not drive. That is also a condition of your bond. Do you
Yes, Your Honor.
understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but you must stay in touch with counsel and he'll tell you if and when you have to come back to court. For now, we'll have you go sign a reset. We'll have you get with pre-trial for your bond conditions, then you're free to go.
All right, thank you, Judge. And I've got one more arraignment, Judge, but I think we're waiting on DVD on that one.
Okay.
So.
Yeah.
Right this way, go ahead and sign. While we're waiting on the interpreter, next is page 5, Barry Hill, come on up. And we want to have Go ahead and have a
Good morning, Mr. Berry Hills. Good morning. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a disturbance call and made contact with the complainant, who stated that the defendant came into his business and was upset that a check issued to him was not good. Upon arrival, the defendant became belligerent with law enforcement officers, and complainant stated he no longer wanted the defendant on his property due to his aggressiveness. Defendant stated he was not leaving until he got his money and was advised 3 times to leave. Defendant refused to leave each of those times and was detained by law enforcement officers.
Okay. Mr. Berry Hill, I'm going to find that there's sufficient probable cause to go forward with your case. Do not go back to this place. Do not have contact with the complaining witness. Do you understand, sir? Yes or no?
Yes,
Do you have the ability to hire a lawyer?
yes, I would like to have a lawyer. I would like a reset, have your lawyer.
Sure. We'll give you a reset now. I'm going to have the state create bond conditions for you. Don't go back to this business. Don't have contact with the complaining witness. As long as you can comply, you and I will be best friends. Otherwise, it's just not going to go well. Do you understand? Don't pick up a new case. Don't become a danger to my city. That's all I'm asking you to do. You understand? So I'll have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it and then you'll be free to go. Please. So can you file no contact, no going back?
Absolutely.
Go ahead and sign. All right, Judge, next is page 8, Saran, come on up.
Okay. Yeah. You don't need to pass your hair for the rent. Yeah. Yeah, okay.
I mean, as long as it transfers some bond conditions, but.
Yeah, I was, we don't need it.
I'm sorry, you ready?
Yes, sir.
You are Mr. Saran. Sir, you're charged with criminal trespass, facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Law enforcement officers received a call for service where an individual stated that somebody was trying to break into her home. Officers observed the defendant matching the description given by a caller around in the area. Officers made contact with the defendant and he was identified by previous booking videos as well as his SPIN number. Officers made contact with the complainant on scene, who advised that the defendant was trying to break into her home. Complainant stated the defendant knocked on the front door, rang the doorbell, and looked through windows of the complainant's property. Complainant observed the defendant enter her backyard, stand on top of a shed to look into windows, and attempt to pull on a door handle to open the door.
And it's only a trespass.
Complainant has surveillance footage of the defendant on her property. Officers searched the defendant and found an unused pipe that officers' training experience indicates it was used for meth. Defendant stated he was a frequent user of methamphetamines. Defendant further stated that during an interview with officers that he was looking for items of value at the above residence in order to obtain money for drugs since he was currently out of money. And I think that the reason it wasn't charged as a burg cab is because he wasn't actually able to make entry into the residence.
Mr. Saran,
Yes, sir.
since 2023, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and now 11 in a matter of 14 months. If I find that you're using any kind of dope, I'm going to take care of it in a way you're really not going to like it. I'm sending you now for a drug and alcohol test because I want to know what, if anything, is in your system. You're ordered not to use anything. And if I find that you do, and if I find that you become a danger to my community, I will grow a horn and tails. Do you understand?
Yes, sir.
I'm putting a GPS monitor on you so I know where you are at all times and I don't want you out in the middle of the night.
Yes, sir.
It's time for you to stop using. I'm giving you now the opportunity to do it on your own. If you're incapable of doing it your way, then we're going to do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
Please appoint him a lawyer. I'm sending him now for a drug test. You were to go test and you were to come right back. I just want to know what, if anything, is in your system.
Yes, sir.
If you fail to test, if you fail to come back, I will issue a warrant. No more PR bonds. Do you understand?
Yes, sir.
Take a seat for me.
All right, Judge, next is page 16, Graham, come on up.
Joe, did you get an ETA by chance or a response on October?
We just request and then they come whenever they come. So I know you got to go. Go do what your stuff and come back and then we'll do it. Or you can do it via Zoom. I know you're busy. I mean, you can always do it via Zoom if you need.
Yeah, no, I was here to build, so I had to.
Okay.
Okay.
Hold on. You know what we can do is, let me see if I have your cell phone. I can text you when they get.
That'll be awesome.
Hold on. No, don't say it. I'd like you. Let me see if I have it first. I don't have it. Do you have a pen on you?
Yeah, no, I don't. Thank you. So, thank you, sir.
Sure, of course.
Yes, sir.
291, right?
Yes, sir.
Okay. Dick, what page?
Graham is on page 16.
All right, good morning, Mr. Graham.
Good morning, sir.
Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir. On April 13th, 2025, law enforcement officers observed a vehicle with an expired registration and conducted a traffic stop. Upon contact with the defendant, law enforcement officers observed the odor of marijuana coming from the vehicle. Probable cause search was conducted of the vehicle and the defendant. Defendant stated he was in possession of marijuana, which was found to be 0.524 ounces of marijuana in his pocket. Defendant also stated that he had a handgun in the center console. The handgun was recovered from the vehicle. All right.
Did you run his, can you run his license?
Absolutely, Your Honor.
Mr. Graham, I'm going to find that there's probable cause to go forward with the case. While this case is open, I'm ordering you not to be in possession of weapons. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
Yes, sir.
Okay, we are going to give you time, so I will have you go to Victoria, sign a reset. We are going to create bond conditions. License?
It's eligible, Your Honor.
Okay, you're not allowed to drive unless you have a license and liability insurance in your name, and that's part of your bond conditions as well. So we'll have you sign a reset, we'll have you go to the box while we get your bond conditions created, we'll have you sign it, and then you'll be free to go. All right?
Sir, thank you.
Please.
Your Honor, there's no driving without a valid Texas driver's license.
And insurance, and no weapons.
Give me approach on my other.
I'm ready, yeah, I'm ready when you are.
Hey, Marco, did you say the 24th?
So again, I've got eyes already on a dozen different courtrooms. We'll continue to ride with Judge Fleischer while he works through his list of arraignments, and then we'll probably look at flipping around after that. But he started early, so he's definitely got a little bit to do. So we'll ride with him for a little while.
Sure, yes, Judge, no, Joe. Good morning, Mr. Child. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
Yes, Your Honor. Law enforcement officers were dispatched to a disturbance at 70 Carlton Woods Creekside. Law enforcement officers observed a white male sitting on the curb of Kukendall Road, arguing with his girlfriend on a cell phone. Law enforcement officers law enforcement officers had received an additional call of a disturbance of two parties coming from neighborhood, two individuals coming from a neighborhood party. They observed the complainant and defendant to be highly intoxicated. An Uber had picked them both up, and they both started fighting in the Uber. The Uber drivers pulled over.
Fighting in the Uber?
In the Uber, yes, Your Honor. The Uber driver pulled over. The Uber driver stated to officers that the defendant was slapping and punching the complainant, who was his girlfriend, who was the defendant's girlfriend. And the Uber driver had called the security officer on duty to get help with the situation. I'm sorry, Your Honor, this is, it's
That's in
reading directly.
DVD's here. I don't know if Sebastian's had a chance to even look at it yet.
Sebastian, stay close to that area, will you? Don't come here. Stay close to that area.
Yeah. Okay, sorry.
So we're just doing PC. All I've heard so far is that they're both highly intoxicated, arguing. He's allegedly punching and slapping in an Uber car. That's all I've heard so far.
So then Uber driver pulled over, called the security officer on duty. But the defendant got out and started walking. The security guard followed him until he got to the beginning of the subdivision. Then officers arrived and observed the defendant on the sidewalk. Officer tried to talk to the defendant. And the defendant started to tell the officer, quote, "Leave me the fuck alone. You people are a piece of shit, and that's all you'll do is treat people with no respect." The defendant started walking towards the officer, dropped the pill bottles, and kept saying, "Leave me alone, get away from me." Officer asked the defendant what it was that they're trying to hide. Defendant said that that's my marijuana. Defendant was combative, telling the officer to fuck off. Officer made contact with the complainant witness, said they were a party, they both got drunk and started fighting when they got in the Uber. And the complainant witness stated that she did not feel pain. I think that's where we're at.
Do they see any visible injuries, anything of this nature?
Judge, as far as that goes, what's in the DIMS here is that the witness stated that he observed the defendant with enough force that she covered her face, fell to the floor, and that the witness observed the complainant based on her actions to appear to be in pain. Specifically that the punch was of such a force that it caused her to fall to the floor of the vehicle and cover her face after she was punched. I think that's where we're at with that.
Again, Judge, to answer your question, there's no indication that there were any injuries at all, any marks, and as he just read, she said she did not feel pain, she did not want to press charges, and I have an affidavit on prosecution as well that I'm going to be getting to the state.
Yeah, so as far as bodily injury goes, of course, we don't need necessarily direct evidence. Pain can be something that can be inferred based on conduct. We understand that, you know, a punch of a certain amount of force from a witness's perspective.
Did they get any statements from the person who saw the punch to?
Again, that was the Uber driver. And that's what the Uber driver said, that based on what they saw, the punch had enough force that it caused her to fall to the ground, covering her face.
The officer goes to interview the complaining witness, I'm
Yes.
assuming, and doesn't see
And
anything?
I don't see any indication that they saw anything.
And she says, I felt okay. And I do not want to press charges.
You know, Mr. Child, there are people in life when they drink, they're the life of the party, they're fun to be around. And then there are those when they consume alcohol, they turn into aggressive, mean son of a bitch that just, they have no business drinking. If this is you, don't drink. You have but one life. You start racking up cases, you start racking up convictions. All you're doing is you're hurting yourself. You know, be nice and good things happen. You're aggressive to cops. You're aggressive here. I mean, the only reason I'm finding no probable cause is because they wrote this report completely, just utterly terrible. And it's over and over and over. But don't drink if you're going to be in jail. You know, really, we have enough death and dismemberment in our city now as it is. Don't be on the news. All right, I'm going to find no probable cause.
Thank you, Judge.
So I don't know about all of you, but I got to be honest, I miss Alex now, because the people they have reading probable cause, I mean, these reports, as the judges said, are just written horrendously, but somehow Alex could always navigate it and get through it quickly and succinctly and give like an actual understandable probable cause. These guys they got now, they're pausing all over the place, skipping around, unprepared, it seems like. So it's like doubling the problem. Give me your thoughts in the chat.
180 days in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 13th, 2025, law enforcement officers observed a large group of performance cars gathered at a location and then saw two of the vehicles line up side by side and accelerate to approximately 100 miles per hour. Law enforcement officers recorded the events, and another law enforcement officer initiated a traffic stop where they made contact with the defendant, who was the driver of one of the vehicles that had took place in this outpacing contest. Defendant admitted to being in the races and stated that he never got out of his vehicle while he was at the race.
Do you have, do we have a co-defendant in this case?
They're checking now, Your Honor.
And number one, number two, does he have a license?
I can check, Your Honor. So the co-defendant is not linked in our system. I don't know if they just weren't able to stop that one.
Right.
But I'm running his license now, Your Honor.
Mr. Barber, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to participate in these types of events again. If I find that you do, first thing I will do is I will put you in jail. And the next thing is I will take away your privilege to drive while this case is open. Do you understand?
Yes, sir.
You're not to participate in any street takeovers, racing, donuts, reckless driving, anything of this nature.
Yes, sir.
His license is eligible, Your Honor.
Can I say one thing?
Do not, don't. Just the only other thing I'm going to caution you is you are not allowed to drive unless you have valid liability insurance in your name as well. If you don't have car insurance in your name, you're not allowed to drive, and that's a bond condition as well. If I find that you do without, I will revoke the bond and put you in jail. You understand?
Yes, sir.
Do you mind filing those conditions?
Doing that right there.
You have the ability to hire a lawyer, sir.
Oh,
Okay, we're going to give you time. I will have you go to Victoria, sign a reset. We will have you go into the jury box while we get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Yes, sir.
Please.
This way. Go ahead and sign, reset. All right, Judge, the next is page 17. Anderson, come on up.
Real quick, Bailey, you're correct. He was third-year law. He was working as an intern under the supervision of the prosecutor. The guy they have now just just took the bar, but hasn't gotten his results yet. So he's also technically working under supervision.
We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12th, 2025, officers observed a vehicle driving at a high rate of speed, specifically going 46 in a 35 posted zone on the officer's car radar. Traffic stop was conducted. Defendant was identified by his Texas ID card. Officers observed the odor of alcohol emanating from the defendant's breath. Based on this, standard field sobriety tests were conducted. Following results: 6 of 6 HGN. Officers detained the defendant, placed him in the back of the patrol vehicle. The defendant did not give a full effort during walk and turn on the first attempt, but did score a 5 out of 8 on that attempt and was given a second attempt, but changed his mind once starting, not completing the second attempt. During one leg stand, officers observed 4 full clues. Defendant was read DIC, consistent to a breath test of 0.143 and 0.134 for the returns.
Mr. Henderson, can you run his license, please?
Absolutely, Your Honor.
Mr. Henderson, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. Do you understand? You will be randomly tested. If you test positive for drugs or alcohol, your bond will be revoked. You will go into custody. No more PR bonds. You understand? You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name.
So I don't see anything returning your own drugs license.
You don't have a license. You are not allowed to drive, and that is a bond condition of yours as well. You will be signing an affidavit with me today. This is a promise you're going to make to me that you're not going to drive. I don't care what your excuse is. If I find that you drive, it's really not going to go well for you. Do you understand, Mr. Henderson? If you want to drive, go get a license, get insurance, and I will happily take the restriction off. Do you understand? Do you have the ability to hire a lawyer? Can you look to see if he has any prior DWIs, please?
Yeah.
No, I did not.
Deputy Miranda's going to give you an application. I need to know everything about you to see whether you qualify for a lawyer. We'll have you sign this affidavit and then we'll have you fill it out, sir. Okay, go for it. Any priors, please?
A lot of extensive out-of-state history, Your Honor, but I'm looking for DWIs. Well licensed suspended for votes,
255.
gain possession,
I need 7. Not that.
leaving the scene of an accident.
Where you're at. You sound change on the number operating the vehicle that valid taking driver's license and non driving whatsoever in states like that. Okay.
Criminal history?
Yeah, it's out of state, Your Honor, specifically in Florida. It's about 27 pages. But I don't,
You don't see
yeah,
any?
I don't, I've done I don't see any driving while intoxicated.
Herman, right?
Yes, sir, may I?
What's the last name, Herman? That's right.
Page 25.
Real quick, Drank, you're right. He did kind of mess up that one case he did get to try. It wasn't pretty, but here at the Courtroom Files, we're forever thankful for his efforts that day, because months later, that video that we did on that still gets 1,000 views a day. So we'll take it.
Mata
¿Usted es
Rojas?
señor Mata Rojas?
Sí.
Yes.
You were charged with
Se
assault
impuso un
of a
delito
family member.
familiar.
You were facing up
Puede recibir hasta
jail
un
and or
año
a
de cárcel
$4,000
hasta
fine.
$4,000 de multa.
We are going to do
Vamos a hacer
probable
razón
cause. Have the
culpatoria.
right to
Tiene
remain
derecho a
silent.
permanecer silencio.
Anything you say
Todo lo que
can or
usted diga lo
against
podemos
you.
usar contra usted.
You have the right to have an attorney
Derecho de-
present. If you cannot afford one,
Para
one will be appointed to you.
a uno. Dice,
Law enforcement
los
officers
oficiales
were dispatched to a disturbance.
una llamada
Upon making
al llegar
scene,
a la cena
they spoke
y
with
se hablaron
the 10-year-old daughter of the
la hija
complainant,
de 10 años de la fijante,
who stated
que
that
dijo
her
que
mom
su madre
was hit in the face
le
by her dad.
pegaron en la cara por su padre.
The complainant stated that she was struck
Ella,
in the head
en la cabeza,
at least 3 times
3 veces
with a closed
con un
fist,
puño cerrado.
while also being
Ellos
kicked
también patalearon
on the side of her
en
torso.
la- en su cuerpo.
While this was going on,
Mientras que esto estaba
the
ocurriendo,
defendant had barricaded himself
salió cerrado
in the children's bedroom
en el cuarto de los niños
of the residence.
de la residencia.
Um, Complainant also stated
También dijo de que
that she was dragged by her hair.
susurraron de su cabello.
The 10-year-old
La
child
niña de 10 años
observed all of this.
observó todo.
The victim, the complainant
Esa
stated
gente dijo de que
that she felt
ella
pain
sintió dolor
during this,
durante
but was unable to provide a
y
number
se pudo dar
on a scale of 1 to 10.
numeración a un 1 a 10.
Yes, Your Honor.
Estaba involucrado algo. Dice sí, sí.
10-year-old witness did advise that the
Niña de
defendants
10 años
have been
dijo
drinking
de
some
que
kind
había
of
dado, había
alcohol.
bebido un tipo de alcohol.
Mr. Mata Rojas, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail.
Te voy a encarcelar.
I want you to know that I will protect every person in my county at all costs. I don't care who you are. I don't care why you're here, how you're here. If you're not in this country with permission and you go to jail and immigration finds you, they will possibly put an immigration detainer on you and you will be stuck like Chuck in custody until this case is over with.
Hasta que se acabe el caso.
Do you understand?
¿Entiende? Contesta.
Sí.
Yes.
Not to have contact with the complaining witness in this case. You're not to be in possession of weapons, and I don't want you to go within 200 feet of where she lives or where she works.
Judge,
Su señoría,
it seems like the
Parece
CW is
que tiene
going
que
to
tener-
want to protective order. I've instructed them if they do, we'll have to come to court and you'll have to see and hear from her if you
I
consider
think the
that.
allegations are,
las
you know,
alegaciones son-
There might be some self-defense allegations as well.
I get it, but all I know is that at this time, Mr. Mata Rojas, I don't want you to have contact with the complaining witness in this case. I don't care if she comes to you. I don't care if Jesus comes down and says we're having a party and she's there and they want you there. Don't have contact with the complaining witness. Do you
¿Lo
understand?
entiende?
Yes.
Yes.
Judge, if she, after like 30 days, if she wants the protective order removed, would you be open to if she comes to court?
We'll keep an open mind. I don't know.
Yes, sir.
All I want to know is that, number one, he's not using. And number two, that she's protected and that she feels that she's not in danger.
Absolutely.
So, I mean, come back in a while and then we can talk to her and we'll see.
Absolutely.
But until that,
Is his appearance waived? I know your rule, but I just wanted to hear from the court.
Mr. Mata, you have a lawyer. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Martinez, and he will tell you if and when you have to come back to court. If Mr. Martinez tells me he can't get a hold of you because you're ducking, dodging phone calls, text messages, or you pick up a new case, I will revoke your bond and put you in jail. Do you understand?
Yes.
So we have a MOAP that has been already issued in this case, right?
Yes,
Yes,
Your Honor.
sir.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate this protective order, the state can and probably will file a violation of a protective order. And that is one of the worst misdemeanor cases you can pick up. For now, we'll have you go to Victoria, sign a reset. You will then get with pretrial for your bond conditions. And after that, you'll be free to go. Thanks, Herman. Thanks for being patient.
Okay. Have as well?
All right, Judge, next is page 9, Cummings, come on up.
Good morning, Mr. Cummings. So you're charged with deadly conduct. You're facing up to a year in jail and a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 11th, 2025, officers were dispatched to a family disturbance call. Officers arrived and met with the complainant, who was ID'd by her Texas driver's license. Complainant identified the defendant by name and date of birth. The complainant stated that an argument occurred between her and the defendant. The complainant stated the defendant grabbed his handgun and held it in his hand as he became angrier. Complainant left the apartment due to fear. Complainant returned to the apartment and contacted the Harris County Sheriff's officers to report the incident. Officers made contact with the defendant. When officers approached the defendant, he stated, quote, "I'm not talking and I don't want to answer any questions." Defendant began to gather his things and grabbed a handgun and placed it in a fanny pack. Officers drew their guns on the defendant, and the defendant stated, "Are y'all going to shoot me? Shoot me then." Defendant complied with verbal commands and was detained.
Is the brandishing of a firearm enough for a deadly conduct? Because does he do anything affirmative? I guess.
So, yeah, and that's, I mean, I would never have a PC hearing, Your Honor. I'd have to do some case law research, but I can see how it's charged is brandishing the handgun, putting the complainant in imminent fear of serious bodily injury. I think the reason it probably wasn't terroristic threat is because there was no word said.
Right.
It was just grabbing the handgun.
Let's do this, Mr. Cummings. I'm going to appoint you a lawyer today so we can figure out, because, you know, we get down and dirty with every case because I want to make sure if I find probable cause, there actually is probable cause. So let's do this. I'm going to appoint you a lawyer today and I'll have him talk to you. And then we'll revisit this PC hearing momentarily, okay?
Yes.
Just take a seat, but don't leave, all right?
Yes, sir.
And then we'll have you talk to some here momentarily. Okay.
All right, Judge, next is
Yes.
page 25, Martinez, come on up.
Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand? If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand this, sir? You have the ability to hire a lawyer.
No.
I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you the Victoria sign a reset, and then we'll have you take a seat. Please.
You're giving follow conditions for the fine.
Yeah. Yeah. With both. No driving and then no without insurance as well.
All right, Judge, next is page 26 and 27. McKnight, come on up.
Raise your hand. Name said Walter Martinez. You sound confirm that you will not operate in public vehicle by out, takes a driver's license and no driving license. On the state side.
Good morning, Ms. McKnight. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
How did that tell me?
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" after you broke my window of the vehicle, of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call in Mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm hurting about that person.
I don't want you to have contact with this person. Do you understand? Are you sure? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides of the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well. You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions.
Your Honor, if you want to wait for the lawyer to set bond on the new case as well.
Yeah, I guess so.
All right, Judge, next is page 31, O'Neill.
You know what? It was a Moab issue.
While we're waiting for the next contestant, real quick, for those of you interested in Ellie, I just went to get her. She's sleeping on her bed outside the studio. Woke up, looked me in the eye, absolutely refused to come in as long as we're watching Judge Fleischer. She mentioned something about feline genocide and then went back to bed. So maybe she'll show up later after we move to another judge.
What page?
Page 31, top of 30.
Good morning, Mr. O'Neill. Morning. Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. All right.
Good morning, Judge. Just 1 second, pulling up right now.
Okay.
Sir.
I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
All right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter, the complaining witness, was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons. Don't have contact with this person. There's a protective order that's been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint you a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants. But I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter.
Okay, hold on.
And
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
the reset happened in a few days.
We usually do like a month.
Month.
I'm gonna have you talk to a lawyer today.
All right, Judge, next is page 31.
Can you find no
Please
contact and no
come on
weapons,
up.
please? And no weapons here. What page did you?
31.
Okay. Good morning, Ms. Ortiz. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge, I missed the last name on this defendant.
Ortiz. Yeah.
All right, thank you, Your Honor. On April 13th, 2025, officer was dispatched to a motor vehicle accident in Harris County, Texas. The officers arrived on the scene and they met with Houston Fire Department, who stated that they observed the defendant to be passed out behind the wheel of the motor vehicle with the engine on. The witness from Houston Fire Department stated that they put the vehicle in park and took the keys out of the ignition. The officers detained the defendant and the defendant was transported to a parking lot. The defendant agreed to perform standard field sobriety tests. The defendant had a 6 out of 6 on the HGN, a 4 out of 8 on the walk and turn, and a 2 out of 4 on the one leg stand. The DIC was read and the defendant consented to a breath test. And the defendant's results of the breath test were 0.086 and 0.087.
Did you say there was an accident?
It says that, yes, sir. Yes, Your Honor. Officers were dispatched to a motor vehicle accident in Harris County,
Did they
Texas.
smell alcohol? Did they see bloodshot eyes? Did they have an odor of anything? Before they started doing all the tests? Are you losing?
Your Honor, I am in the DIMS. It does not say. Yeah, I know. In the DIMS, it does not say I am checking the offense report. I know. I know your feelings on that, Your Honor.
Mr. Ortiz, If you watch the news every single day, we have someone dying from a DWI in our county. It's not cool. If you want to go get lit, fantastic. Take a freaking Uber. $40 and one button on your phone. Anywhere you want to go, man. I'm going to find no probable cause in this case. Just be careful. All right? Please.
All right, Judge, next is page 36. Paper.
So yeah, guys, I agree. Reckless is an interesting thing to wear. Let's hear from this guy, and I'm going to tell you about something somebody else was wearing in another court.
You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I can do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria's Sign and Reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to.
Okay, well, there's one. Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one that could be ready. Theo, come on up.
Okay, we can get Barbara out of here. You want to bring? Barbara, come on up. We'll have you sign. He's THA, so we can get him out. And then.
Just one second. Have you signed?
What is it?
It's in one here, I should just go, I'll let you know.
No, I'm saying what's the condition?
I put judgment here earlier, basic, so I'll take a part, yes, take all these.
Okay, what page?
Page 37, Steele.
All right, good morning, Mr. Steele. Sir, you're charged with evading arrest or detention and theft. On the evading arrest, you're facing up to a year in jail and or $4,000 fine. On the theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, officers were dispatched to a theft in progress call in Harris County, Texas. Officers were given a description of the defendant by an Academy employee. The officers observed the defendant walk out of the store passing all points of sale. The officer attempted to detain the defendant for investigation for the alleged theft. The defendant initially complied with the officer directives. As officer grabbed the defendant's wrists, the defendant began to pull away and evaded through the parking lot. The defendant eventually tired out and officer detained him without incident. The defendant evaded approximately 1,271 feet. The officer confirmed with the reportee that the defendant detained was the one who stole a paintball gun, and officer located the merchandise in the bushes at the Olive Garden where the defendant stated he dumped it. Initially, the defendant denied taking anything from the academy, but when confronted with being told store cameras caught him in the act, he admitted it and led the officer to where he dumped the paintball gun. The paintball gun was retail priced at the store for $140.
Mr. Steele, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to go to any academy. Do you understand? How old are you, sir?
17, sir.
Are you here with anyone today?
Yes, sir. I'm with my sister.
I'll appoint your lawyer today. All
Yes,
right?
sir.
Don't get in any more trouble. I don't want to have to put you in jail. You know, if I put your bond at $5,000 to $10,000 and you don't have anyone to put that kind of money up, you'll be stuck like Chuck, man. This is not a good way. All right?
Yes, sir.
So what I'm going to do is I'm going to have bond conditions created for you. Don't get in any more trouble. Don't go to O'Reilly's. What are you doing with yourself? Are you in school? Are you in high school?
Yes, sir. High school. I'm in 10th grade and I'm trying to find a job right now.
School. That should be your one and only gig, you know? That should be your full-time job because the most, you want a paintball gun? Money. You get money with knowledge. You get that with school. That's your full-time job. Do you understand?
Sir.
All right. I'm gonna have you sign a receipt, Victoria. We'll have you just take a seat in the juror box while I find your lawyer, okay?
Yeah.
Please. We found they're going to academies.
Andy Berryhill?
Okay, well, he's between people. I told you that I was going to point out something somebody else was wearing because he had somebody wearing a shirt that said reckless on it, which was funny and stupid to wear to court. I'm also watching 13 different courtrooms right now. Judge Raquel West did a sentence about a half an hour ago, and that defendant was wearing a shirt that said Jeremiah 29:11 on it. And just to point out what Jeremiah 29:11 says, "For I know the plans I have for you, declares the Lord, plans for welfare, not for evil, to give you a future and a hope." Somehow that seems more fitting and obviously a message to the judge of have mercy on me, but probably a better choice to wear to court, I would suppose. Let's get back to judge.
Hey, Mr. Garcia. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On June 7th, 2024, officers were dispatched to the complaining witness's residence and met with JV, a minor. The defendant is her older brother. They were having an argument because someone went through his items in his room. The defendant kicked her in her midsection area, causing her to fall on the floor, and struck her with a fist several times. Her younger brother also witnessed this. She felt pain. Defendant left the location before the officers arrived. That concludes.
This is old, huh?
Yes, Judge.
This is from 2024. We're just now getting it? Is it a 2B?
Yes, Judge, it must have been a 2B. We do have another offense from a 2024 date as well, so I'm not sure what brought them in this day.
Mr. Garcia, I'm sending you for a drug and alcohol test. I want to know what, if anything, is in your system now and you're to come back. If you ever take off again, I'm going to make your bond extremely high. No more PR bonds. Do you understand me?
Yes, sir.
You are on bond for a felony as well. Will keep my county safe at all costs. You understand?
Yes, sir.
I'm going to appoint your lawyer today, but I'm sending you for a drug test. You must take the test and come back. You understand?
Okay.
All right. I want to send him for a test.
Can you send these charges?
All right, Judge, we do have a few more agreements, however, the attorney does not.
Oh. Okay, we'll wait. Then let,
Councilor Richard?
Mr. Martinez, come on up. No, I'm gonna deny this one.
Yes, sir.
You know, you make too much money and you have virtually no expenses. No, right there, right there, right there. So, I mean, you can afford a lawyer. You make,
I was gonna ask a question.
don't. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're gonna use it against you. Just what you need to do is you need to go hire a lawyer. There's a gajillion and one lawyers out there. So go out there, don't accept the first one, negotiate with them. 99% will put you on a payment plan where you pay a couple $100 a month. You just need to find the right one for you. All right. So just take the seat for me. I'm gonna have you sign a reset and we'll get you out of here.
All right, got it. Thank you. Get it out for you. Okay.
So I told you we'd run with Judge Fleischer until he got done with his arraignments, and he's still going, and we've been with him for 45 minutes anyways, probably longer. If you're all right with that, I'll stay with it. If you have a different opinion and want me to start switching around, just let me know in the chat. Normally I switch more, but, you know, here we are. It's a busy Monday, and people love Judge Fleischer, and he's got a lot going on. But let's see.
Judge, we did have one Spanish arraignment,
Okay.
page 23, Lopez. Lopez.
Todo a voz alta.
What page did you say?
Page 23.
Is Victor Lopez?
Yes, sir.
Mr. Lopez, you were charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Your Honor. On April 11th, 2025, in Harris County, Texas, officer was working patrol when he observed a motor vehicle that matched the description of a vehicle that was recently stolen by 3 armed Hispanic males. The officers conducted a traffic stop. The defendants disregarded officers' verbal commands by staying in the vehicle. The driver continued to disregard commands by putting the motor vehicle in drive and operating the motor vehicle through the parking lot. More specifically, the driver drove approximately 20 miles per hour toward Officer Martin and his motor vehicle. The driver continued to evade for approximately 2 miles until the vehicle was damaged such that it could no longer operate. Defendants were detained and a stolen handgun was located under the driver's seat. The complaining witness mentioned that he was robbed at gunpoint by 3 Hispanic males who took his motor vehicle without his consent.
Charge anyone with the aggravated robbery?
We do not. I do not see that here. I'm not sure.
Mr. Lopez, I'm going to find that there's sufficient probable cause to go forward with your case. Was this in the middle of the night? Was this in the middle of the night?
Medianoche.
This was.
I don't know
Yo
what
no
your
sé
immigration
cuál es su
status is,
estado
Michelle.
migratorio, señor López, pero si no está en este país con
End up going to
permiso
jail.
y termina yendo a la
Immigration
cárcel, la
finds you.
inmigración lo
They
encuentra,
will enter
ponen
on
un
you and
sostén
you will be
usted,
stuck like
se
Chuck
queda
in there.
ahí como el Job hasta que este caso se
I
termine.
want you to
Yo quiero
understand
que
that
usted
I'm
entienda
everything in my
en
power
todo
to protect my
bajo
city.
poder para proteger a los ciudadanos
And that you become a
que se
danger.
encuentran que usted es
It's
peligro.
really not going to go well.
Eso no le va a ir bien, usted lo entiende.
Yes, sir.
I'm sending you now for a drug and alcohol test, and then you're to come right back. If you fail the test, if you fail to come back, I will issue a warrant for your arrest. Do you understand?
Entiende.
You're ordered not to use alcohol, illegal drugs, and I'm putting a monitor on you so I know where you are at all times, and I'm giving you a curfew because I don't want you out in the middle of the night.
Quiero que usted esté por allá afuera.
Tell me you have the co-defendants, please, so we know who they
Dígame que
are.
tienen a buena de
Cole, the co-defendants, so I know who to tell them not to hang out with.
para que usted pueda decir con quién no debe estar.
We have a
Tenemos
couple of names
un
here
par
in
de
the,
nombres
Can you just give
aquí.
me like a cause number? That'd be great.
all right. The cause number is gonna be 255-956-2.
That's our cause number.
Oh, the cause number for the co-defendants. I don't see it here in the damn, so I'm pulling up the offense.
Is Bonilla the only co-defendant?
Bonilla and Hernandez, I believe.
Okay, I don't have Hernandez's case number.
Can you give me one of the cause numbers that you have?
Yes, Judge, I have Bonilla, the cause number is 255-9576.
Your Honor, I have Hernandez if you would like that as well.
Tiene a Bonilla y Hernández.
Yes,
What
sir.
is it? Hey. What's the other cause number, Cole?
It is 1911823.
Okay. So they got Hernandez on the act of assault with the evading.
Yes, sir.
And the evading.
Robo con agravante.
There's a problem with the three case. It looks like they put the defendant as the lawyer also as the, and I don't know if that's fair. So they take care of it. But if you want to take a look, they put the defendant as a lawyer. Mr. Luke, it's 255-9576. Mr. Lopez,
Señor López.
I don't want you hanging
Yo
around
no
with the other
quiero que
two
usted esté con
co-defendants in
los
this
dos
case.
acusados en este caso.
Find that you hang
Si
out with them.
encuentro que está con
Likewise, I will
ellos,
revoke your bond, put you in
igualmente le
jail.
revoco su fianza y lo pongo en la cárcel.
Don't
No,
danger my city. Do you understand?
ciudad, ¿lo entiende?
Yes, sir.
Okay, I want to sign now. Okay, take a seat for me, sir.
Judge, do you want me to appoint or we wait?
Yeah, no, of course. So, no weapons, no contact with the co-defendants, no using GPS with a curfew, please. The curfew is 9 p.m. to 6 a.m.
It's me corrected. They have a John,
Yeah, that's right. That's the lawyer.
Good, that's good for now.
Okay.
Now, to hold it up. Do you want to start the judge?
Yeah.
Okay, I'll start it right away. Do we have?
You don't need me?
Not yet.
Okay.
Well.
Okay, looks like things are slowing down there a little bit. So let's start moving around a little. Let's go to Judge West, who I mentioned a few minutes ago.
amphetamines and ecstasy. And so at this time, I'm going to find that that is a violation, obviously, of your bond conditions. And I'm going to raise your bond in your case to $100,000. Well, let me look at it real quick. I'm going to, let's see. In one of your cases, you're charged with assault on a peace officer, the other credit or debit card abuse. In each of those cases, I'm raising your bond to $100,000 in each case. If you make the bonds in those cases, you are ordered to wear a drug patch at all time, get it tested at the appropriate times, and then we will move forward with your case.
Can I ask a question, please?
Mm-hmm.
Am I about to be arrested in?
Yes, you're going into custody right now.
Okay, I have a child.
You shouldn't be using ecstasy and methamphetamine. If you have a child, you can go back with the bailiff.
So I.
Go back with the bailiff right now. Go back with the bailiff. Go with the bailiff.
My child is missing and he's with a terrible person. He's the only thing that.
Yeah. Good morning, Mr. Lewis.
Child's with a terrible person, but she's doing ecstasy. Which one's the terrible person, I guess? Judge Meineke, let's say good morning to him.
It's on the 26th, and then showed up for 331 test, and then didn't show up on April 7th. There was some question, I believe, from Ms. Murphy as to whether or not she needed to continue to test.
A little abrupt, but let's go back to Judge Fleischer, because I think we've seen this guy before. Let me know in the chat. He looks familiar.
So we were gonna drop your I thought it was, I thought it was 2 months after initial setting, and we are now not quite 1 month out. Because I was appointed on 3/28.
Melendez. 18. Now, within 2 months, have now 2 convictions on your record. If I take this, why would we keep letting you get convictions on your record to hose yourself? You want to take the easy way out in life. That's not a good way to go. Because now you are just making it all the more difficult to get jobs. You want to get funding for anything in this life, not with all these convictions you start racking up. Did you start the framing job or no?
Oh, well, he didn't like answer me the next day, but I've been doing school. And I have like every day I do it.
In fairness, I did receive emails showing that he just passed his last course and has now moved on to the next one.
So what course is that?
I went through the mental health, now I'm in US history.
It's great. You don't want to do a probation to try to keep this off your record?
I don't want to deal with it no more. I've already been coming for like 5, 6 months. I don't want to keep coming and doing it.
When you pick up cases, that's what happens.
I know.
You know, when there are. Half-ass approach, you get a half-ass result. Now you will end up with a second conviction. You don't want a probation. If you do it, right, depending on how well you do it, I take people off early when they do well. All you have to do is stay drug-free and do probably a class or 2. If you do that, you don't end up with a conviction on you. It's up to you.
It's a strain. It's a strain on my family. It's a strain on me. Like I have to get my mom to come here every time with me. She has work to do. My dad works.
What you would do is you would report by where you live. You don't come to court anymore if you get on probation. Have you talked to him about a deferred?
I just got the offer from the state. I did not discuss it deferred with him. When I talked to him about the ins and outs of things, he told me he preferred the idea of a time served. So that was what I asked the DA for. I did not even ask for a deferred.
You gotta understand that you're only hurting yourself more and more and more. You now, from now on, are looking at a minimum of 90 days in jail, any new cases that you pick up. If you get buyer's remorse within 30 days, we can talk about it. If you have a change of heart where you would want to prefer to do something else, come back and we can talk. But after 30 days, I lose jurisdiction. This ends up as a conviction on your record for the rest of your life. You can never take it off. You understand? You're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you've worked out is 3 days in jail, credit for the 2 days that you've done. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You sure you want to do this? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. I'll follow you. Good luck to you, Mr. Melendez. Thanks. Thank you, Judge. You rolled it. Hey. Hi, good morning.
For this one. I have Collins back on docket. We're in the same place we were Friday.
Yeah.
I reached out to her felony attorney and I called him and nothing so far. She goes back to Galveston County on the 23rd.
You mean she goes back?
So she goes to see the judge on the 23rd. But I'm trying to get.
In 2 days?
Yes. To see.
Set it for after that?
Yes, Judge. Also too, spoke with the chief. He said to see if you would consider, if we can verify she was in Galveston County from the 27th of January till now. Think about giving her credit for that time while she was in Galveston.
Zircon?
Possibly, but we still have to
I
worry
mean,
about getting her back here.
if someone's in custody and that we had a hold on it, of course.
We're just trying to get her to here to do anything because they offered a deferred on her case. But somebody would get her.
Offered deferred here on
Yes,
this.
Judge. Yes,
Okay.
Judge.
What do you want to do? Do you want to set it for the day
Can we,
after?
at the after, because. I don't know how to get it. Yeah, 23rd. Yes, at the 24th possibly. Perfect. Thank you, Judge. You get me thinking out loud. Everything I'm like thinking out loud. Thank you. May I have excuse, Judge?
Yes, ma'am.
Thank you.
Bailey, I agree. People are often short-sighted in their thinking. Let's go back to Judge West real quick. It is definitely themed shirt day in the various courtrooms.
And Mr. Patterson is charged with driving while intoxicated, third or more. Mr. Macon, what is the announcement?
Your Honor, that's going to be a plea. I'd ask for a short reset just so that we can coordinate him getting into my office to go over everything.
All right, I'll reset. This will be the last reset on this case. Mr. Patterson, it's important that you call. Don't wait till the last week before a court date. Call, make an appointment, go visit with Mr. Macon, go over everything so that when you come back, you'll be able to either take care of your case with a plea or it'll get moved to the trial docket. All right, thank you. And I'll, as soon as you're ready on Mr. McCain, I'll call him back up.
All right. Well, she's muted herself. Let's go back to Judge Meineke. We haven't seen him in a little while.
The bond review either. So I just didn't have a file or anything on this one.
The court had to move swiftly because I heard about these things, and before there were further violations, the court wanted to address it immediately. We have a pretrial date of May 5th, and we can keep that. Make sure about that. Yeah, May 5th. So on May 5th at 8:46, we can get into, how the case is going to go. And Mr. Phillips can talk with Mr. Klusny, and Mr. Wu, you can talk with Mr. Phillips in the meantime. Let's let this process play out. All right. Do you understand that, Mr. Wu? So bond violations have been
Yes, I do,
addressed.
sir.
Any future bond violation will likely result in incarceration. And see everybody back here on that May 5th date. Thank you, Mr. Phillips. Thank you, Mr. Wu.
Thank you, Your Honor.
Thank you, Judge.
Your Honor. Thank you, counsel.
You can log off. You're all set now.
All right, well, he's gone a little bit quiet. Let's go over to Judge McGrumpy. McNally. Or McGrumpy, either way.
Well, I can't do that unless Mr. Badari. Look, Mr. Badari, is there any other agreement besides that amount? Consent judgment 644-756 in favor of the plaintiff and against your client?
We may be amending it in the next 21 days in terms of a monthly installment plan, but if not, it's going to just stay as is. And defendant will file a motion for installment payments.
I see.
Your Honor, also, if I may, I would also indicate defendant counsel agrees to dismiss his counterclaim with prejudice.
You guys are submitting paperwork for all of this, right?
We can submit it to Mr. Badari, yes, Your Honor. It's fine. Yeah, I don't think there would be anything in the file that would deal with the counterclaim. So I guess
I'm not going to say anything that only has your signature if it's a consent judgment. So maybe you need to submit that with permission, if Mr. Badari is willing to give it to you, to sign his name to that. And then you guys can submit the stip in order to dismiss the counterclaim. You could prepare that and that would be with prejudice, right, Mr. Sloan, Mr. Badari?
Correct. It would
Your Honor.
So
Why don't you guys just grant each other permission to sign your names to those and you can send it over today?
Mr. Badari, do you give us permission to sign your name by consent to the consent judgment with the terms the court placed on the record?
Yes.
And do you also give us permission to sign your name by consent to a stipulated order dismissing your counterclaim with prejudice?
Yes, thank you.
Okay, thank you. Your Honor, we'll prepare it and send it to the court then directly.
Thank you very much. Anything else, gentlemen? Mr. Sloan?
No, Your Honor.
Badari?
Try to work on it.
Thank you.
Yeah.
Thanks a lot, guys. Have a good day. Thank you.
Likewise.
Thank you, Your Honor.
Why have the parties ready on Capital One and Boot Bond?
So let's go back to Judge Fleischer's court.
Portillo Lopez. And he's got 2 cases. He does have an immigration hold, Judge. He's in custody.
Okay.
And he's got,
Counsel, will we set?
Can you call a translator? Victoria, can you call a translator? That, whatever you want.
that's right, Judge.
Tell me, you
Right.
want a week, 2 weeks, fine, whatever you want.
Right, Judge. We'll approach Wednesday.
Oh,
Interpreter, yes, Judge.
Unless, if you don't mind, we'll wait for that, then we can.
Yes, Judge, sure. Thanks.
I think it might be her petite size or her hairstyle, or I'm not sure what, but every time I see that attorney, she reminds me of the lady in The Incredibles who makes the outfits for the superheroes. I don't know if you know what I'm talking about or not, but every time I see her, that's the first thing that comes to mind. Anyways. Yeah, let's stick with Judge Fleischer for just a few minutes.
Counsel for reset?
Call me up at THA.
Page 4. Bottom of 4.
Okay. Baudouin, come up. Good morning, sir. Do you have a lawyer?
I have one and then got called Thursday. They said.
What do you mean? You were supposed to have one.
I had one hired in, but they had a husband go to a hospice, so they wasn't gonna make it.
Did you hire them?
It was to do a family friend.
Okay, so are you going to hire them?
Yeah.
One more time?
If I can.
Sorry?
If I can.
Sure. Yeah, we'll give you another reset. Just make sure to have the lawyer when you come back.
Okay.
All right, just hang tight. Or if you want to head that way, why don't you sign everything?
Okay.
Right of it.
All right, go ahead and sign. Do you have any-
Let's head over to Southfield, Michigan. Judge Sheila Johnson looks like she's about to sentence somebody.
Eyes, cost here. That's number one. Number two is she isn't treatment. He has been, I think, ever since the outset of this case, she has a letter from the organization. Even treatment helps them see it.
Yeah, what's the name of the place?
Cities, I believe. I have it here. Like to see it.
Central City Health.
Yes. The best view of this letter is the people like. See?
Sure. All right. Yes, this does indicate that she is under the care of a the case manager is Gloria Rooks. She's a master of social work and a QMHP, whatever that is. And she does indicate that she was discharged July 29th and has continued her monthly appointments after her hospitalization. She does take some injections. Okay, good. Anything else?
Well, I would wonder or ask if the court could arrange some kind of probationary sentence whereby as long as she continues in treatment, and that organization provides regularly updates as to the fact that she is in treatment, whether that would be sufficient for, reporting requirements, whether then it could be done by phone or.
I don't get into that. The probation can do that, and they can report by phone. They can report by Zoom. She doesn't necessarily have to come in.
So ultimately, I don't think there's any.
I mean, this is real reasonable to me. Got some issues, and she needs to maintain her current course of treatment.
Of course.
Yeah. What do you wish to say?
I just want the, I'm probably security, and I'm waiting on my response. I just want the money. For my responsible. I'm kidding. So I don't be in
Oh, I'm glad you don't think that you need it. I think that you should definitely continue what you're doing. And I don't think an anger management class is going to hurt you, because it's what it's going to do is give you some new information on how to work through things. Once you're calm and you're on your medication, if you get angry, that's fine. You can be mad about some things, but it teaches you some alternative methods as to how to release that anger rather than, going ballistic.
Yes, we have to call a doctor. I'll take 911 call them.
What's not that complicated?
Well,
don't you care about his for
angry too. So, you know what I mean? I just responded to because I didn't want the police to go off why I didn't send it. I didn't get angry.
Well, that's what it says in the report, that you denied that you did anything.
You see, he was playing with 911. And he wouldn't show up in court. So they didn't say that what he said. He was afraid that he would start calling my face.
Well, I guess I'm wondering, why did you plead guilty here?
Just with an empty body and him not being here, him not showing up, the police going against somebody coming outside.
saying something happened to him. You know what I mean?
Well, he would have had to been here for trial or at the circuit court if it went up there for the felony charge. He would have had to come or else they would have dismissed it. So I don't know. You pled guilty and we took a guilty plea. It was a no contest plea, and I looked at the report to see if there was enough information. But you know, the bottom line is, Miss Mills, you got to just get away from this person and start focusing on you. See how? Okay, so you've got a good amount of life to live, at least another 40 years, probably, if you're in good health. So what are you gonna do with the next 40? You're gonna waste your time with this guy on this situation. So now get better. Now take your meds, continue with your counseling, and decide what you want to do with the rest of you, because you got a lot of options here. As long as you get your condition under control, and it sounds like you're doing really well with that, and you're doing what you're doing. Maybe you go back to school. That would be great. Yeah, because you have a 7-year-old. You want to show him the way to do it, right? Look, Mom, she stopped, but she went back and she got it. So I want you to do the same thing. Plus, guess what? You probably put yourself in a position to get a pretty good job if you go a little bit past high school. And that's what you definitely want. And you won't be worried about, well, I don't have enough money for this or that. And it's a slow process. You sign up for the classes, you take what you can, but you can pay for. May even have some scholarship money, who knows? And then you figure out what you want to do and you take classes in that area. And then that way, you're moving forward. And, whoever this person is that you guys just don't get along for whatever the reason is. So you just got to let it go. It's hard, I know, but sometimes, do you feel a little bit better off now since you haven't been talking?
Yeah, I still try to fall, but I just told him I got the baby that are staying with our parents. So I just feel better, but he won't let it go because he was lying. You know what I mean? He feel like he didn't lie.
Well, you don't need, if he did lie, you don't need to be with a liar now, do you? Nope. And you can certainly give him the visitation that he's entitled to. You don't have to necessarily be involved with him. So this might be the best thing ever happened to you. And then you go find a nice guy who won't lie on you, that you get along with better. But you can't do that if he's in the way. Mm-hmm. Okay.
Whether the anger management component that is available through the organization and servicing her presently would suffice.
As long as it's anger management, I really don't get involved in it specifically where.
Okay, great.
So, Mr. Shockley, anything from you?
Nothing with the evening.
All right. So I'm going to follow this recommendation. So it will be for a period of 12 months of probation. Okay. On this aggravated domestic violence charge, I'm going to charge a $300 fine. I'll suspend the oversight fees. She'll have to do 2 days of community service in a nonprofit agency, no alcohol or unprescribed drugs. We want her to continue her treatment. This is at Central City Health. And take her prescribed meds. She might have to sign a release so the Central City can send information to probation. Anger management classes. And if she can do them, they offer that, I don't know. But she needs to go to that. And we'll have no contact with the gentleman who was the father of the son. They've been having issues together. His name is Eugene Williams. Yeah, no S. There is a $75 crime victims fee, and there is a $100 PSI screening fee. And let's see. I'm not gonna order drug testing or alcohol testing. And there's a $200 counsel fee. She has the course of probation to pay on these things. I did waive the big thing, which is oversight fee. And if she can't pay, she can do extra community service work. We give after the 2 days you do, if you want to do more, we will give you credit for $10 for every extra hour that you did against your fines and costs. Yeah, and obtain employment if you can. Oh, well, if you get that, then you might not be working. Unless you're receiving the Social Security.
What's the total amount of that?
They'll tell you probation. I don't have time to add it up. Attach this to the file so that they can see where you're being treated.
24 months of probation on it.
12. Okay, there we go.
So she needs to go down to probation.
They'll take her down. Yes. Good luck, ma'am. Charles. Kieran S. Are you looking for him?
All right, the Casman, you mentioned a little while ago that everybody's Sunday's best must be in the laundry. Let's go back to Judge West.
Brandon, Mr. Brandon, I'm gonna have you tested this morning. Do you have your drug patch on now?
Yes, ma'am, but it was opened up. But I tried to keep it on.
Okay, so you're having issues that we've gotten emails that there've been some other issues. People wear drug patches all the time without having issues. So you gotta figure out how, she said they showed you how to wrap it correctly and all of that. Have a seat in the jury box. We're gonna get you tested this morning and make sure that there's nothing in your system. Then we'll get an announcement. And Caden Jones. I think that would be, I might want to do.
You know, I won't do it because, quite frankly, I don't have the time, but I could make a super cut of all of the t-shirts that people have worn across the previous courtrooms that I monitor here this morning, and it'd probably be like a 10-minute super cut. I swear to God, it's nobody is dressing well. Well, this person's not too bad.
Announcement.
Yes, if we can get one more announcement. This is our first setting. I believe we'll be able to get this resolved after my conversations with the prosecutor. If we can just get one more reset.
All right, Ms. Jones, I'm going to reset your case about 30 days. It's important that you stay in touch visit with Ms. Holmes before that next court date so you can go over all the information that she's received, and we'll get an announcement at that next court date, okay? You're free to go. Rodney Ladiolas, Ms. Holmes. Good morning, sir. Are you Rodney Ladiolas?
Yes, ma'am.
And will your client waive the formal reading of the indictment? Sorry, it's just spinning for a minute.
Let's go back to Judge Fleischer.
Well, because she has taken off literally. Yeah. This case is from 2023, and she has taken off 1, 2, 3, 4 times.
Okay, that's what she was
So
trying to explain to me. So I understand why. I just had to.
explain to him. I'm happy to do that. I can always bring him out. You let me know, and I'm happy to explain.
No, that's fine. I just, on these cases anyway,
They don't show up.
honestly, yeah, I know.
So
I had to come up and ask, but that's just, in
Let
the
me
long
know.
run, appointing a social worker and getting some treatment to them while they're in here is probably better for them. So
look, if you have a social worker to them and you find a place where they can go to, and we know somewhere that's gonna take them like a family member,
Correct, correct.
then I'm willing to talk to you. But I'm not gonna let them out just to go to the street, because this is what happens, right?
I understand, Judge. Okay.
So let me know.
Thank you.
Dick.
Hey, Judge.
Hi, bud.
There you go.
Judge Daniel Melgar was approved for PTI at 7:33, but then we got an email at 10:30, 10:20, that one of the pages of the packet, 10:32 needed to be resubmitted. One of the pages was, I guess, scanned not cleanly.
Okay.
So we're doing it right now.
Okay.
So I don't know if you want to roll it to tomorrow.
No, I trust you to get it
Okay.
done.
I looked at it, it's not clean. I mean, it's just kind of
But after that, you have to pay the DA fee.
it's already done. Everything's done. The DA fee is done, the interlock is installed, we sent everything back in Thursday
All you need
afternoon.
is that for the,
We just need the one page to be resubmitted, roll to tomorrow. Does he need to be here? Okay, thank you,
I
Judge.
mean, if it's not done, yeah.
No, it's, my office is working on it right now. Okay.
We'll wait. Okay, hi, Darla.
Hey, Judge, I'm approaching on Hernandez, first name Francisco.
Okay. Hernandez, I'm looking back in zone. Come on. Okay.
It looks like they,
Oh,
the state's asking
case.
for bond condition, correct?
Francisco Hernandez, coming up. Euler,
Not getting hold of it.
Euler. You want to go look? We'll hold your place.
Thank you.
Hey, cheers. Happy Monday.
To you as well. And,
What's going on?
Well, we're approaching on a couple of different cases. I think one is the Andy Lara case, which is set for trial tomorrow.
Okay.
Lara. And, but the state is anticipating dismissing that case. He's apparently done a plea in felony court.
Okay.
And he's going to take a TDC sentence. It looks like his report date is May the 7th.
Yes.
And so we're asking your permission to remove it from the trial docket for tomorrow.
I mean, if you know you're going to dismiss
Oh, we're gonna
it,
dismiss it. It's just the only thing is.
what if he doesn't go do it though?
That's the thing. So I would ask to just move the date to May 8th. That's the day after his report date. If the reports were good, I'll dump it that day.
Sounds like he's already played.
He's already pled.
Oh, you ready?
He's already pled. It's not a plea issue. It's that he's pled. He just needs to show up to get sent off the TDC.
Why keep it? If you know he's pled,
So,
you know,
Your Honor,
the
the thing is, I think there's concern. I think Melanie just wants us to make sure. I know there's a bail jumping that can be filed.
I defer there.
Your client here?
Well, no, he wasn't required to be here today.
But because would like you to impart to him that if he fails to show.
Well, there'd be a warrant.
Well, no. But the entire range of punishment is at stake. So what's he looking at? Is it a second degree? No, do you know what's the last name?
Lara, Lara. What was the?
Is it a second degree or third degree?
It is a, I'm gonna go for it. And it's an MAJ, Your Honor, so it's not actually a. trial.
Oh, then that's even worse.
Right.
Let him know if he doesn't show, he could get the full range of punishment, you know? Yeah, I'm okay with doing what you want.
Okay.
Yeah.
And the next issue we've got is the Brandon Lane jail case, Judge, and that's on your docket this morning. And that gentleman has several theft cases that are pending. You will recall that this is the gentleman we looked at doing a TRAS. TRAS came back with having issues about competency. did a competency evaluation, came back competent, but I don't see how.
So get a second opinion.
Well, and I think what we need to do at this point is just the age of the case, and that's what we're working on getting accomplished. But is getting a date in the future just locked in now to have maybe a competency trial. And we'd like to get that in, but I think we could meet our burden of, well, I think we could meet our.
You ever done one of those? Me neither.
I've never done a competency trial, but I can reach out to Brad.
Interesting.
What we need to do, what the procedure is, because I'm assuming there will be.
If you want to just set it maybe like a week, you can look into it. You okay with that?
We'll set it for a week to be like.
Still evaluate, yes.
Just so I can reach out to Brad and be like, look, I've never done one of these, I'm not an expert now.
Well, and Brad may have some creative solutions that get us to a fair result, because he's been in custody for over
I don't
60 days.
understand. If you don't think he's competent?
No.
So
And
how on earth I I don't understand how.
well, so we had an agreement before that put him on mental health PTI. And
I don't understand how a clinical, a licensed, I guess it's can disagree with you on this.
well,
I guess
I think
reasonable
if you-
lines
if
different.
you read that-
I just,
report, I think even within that report, it says things like, well, he's maybe incompetent in hearing delusions and stuff at times, but he can still help his lawyer, and that's just not the case. And so, I mean, even the competency report finds that he's having delusions, and that was what he experienced when he did the T-Rex. And so,
I'm willing to give you money if you want to go hire someone to have him reevaluate.
yes, well, and that may be what we need to do.
No?
But I just don't want him, I mean, the problem is he's been in custody for 60 days now and picked up a new case while on the PTI, exact same allegation. And so, but if you talk with Brad, you may find out something that doesn't prolong this. So a week.
See where you guys go.
Yes.
Up with, and then I'm all ears.
Okay.
My other concern is this, is that at some point he's going to get out. Where is he going to when he gets out? Is he going to the street?
Well, and that's why
does he have family members around? Does he have anyone around that's going to take him?
Nope. And that's why doing the mental health PTI was appropriate, because they have housing options over there. And it got him short-term housing. And that's why I went that way.
Stay.
Well, and they can help you when you're in that program, apply for longer-term housing. That was the best resources that I could help the gentleman get. And that's why we thought that was the most appropriate.
Every weekend we'll go through.
Thank you, Judge.
Ashley, I don't, excuse me, I don't have a complete answer to your question, because to be honest, I don't pay much attention to those things regarding other people. I believe he's talked about being Jewish, but I don't know for sure. The only thing I can tell you for sure is that one of his parents is from Chile, and that's why he speaks such good Spanish. That much I know.
Come on, Mr. Palacio.
You need a copy of the bond violation, Judge? Okay.
Second bond violation. What am I supposed to do?
So his first one was because he picked up a new case. This one, I did speak with him. He is actively in IOP. I did show you those records at the last time that we were here, that he got involved in IOP. He is getting drug and alcohol tested at his job too. He is a Marine recruiter. He did pick up some non-alcoholic beer. A lot of them still have alcohol in them. He was trying to still hang out. I get it. He realizes that that's obviously not going to work either at this point, that we're staying away from everything. But he did go get that.
I have to beg you not to violate your conditions of bond. Am I supposed to just be happy and let you go again? Either you have a problem or you just don't care about bond conditions.
Yes, Your Honor. I did.
I just, whether you say yes, whether you say no, whether you say Your Honor, I already know, I know my name. I don't. The point is that you just don't get it. And what do I need to do to ensure that you don't get it?
So I have had several conversations with him, Judge. He is taking this seriously.
You had conversation beforehand.
I understand. He is actively involved in his IOP and has been continuously going to that. He is trying to make a change. He thought that he was doing something better for himself at that point. Obviously, that didn't work out. Right after do you remember the date? It was in March, right?
Yes.
Let's see.
I have like 2 weeks left.
So, let's see.
Okay, so let's do this.
He had an initial appointment February 12th, but he did go into custody at that point. So then he had to reschedule it. So the beginning of March, he got involved.
Sending him for a drug and alcohol test. now.
Absolutely.
I'm sending you for a test now and you're to come right back. If you fail the test, you can fail to come back. I will revoke your bond. Do you understand?
Yes, sir.
Okay, take a seat for me.
Okay,
And then
let's judge.
just leave me your cell phone and then I'll get a hold of you.
Okay, do you want it now?
Don't speak it out loud.
Okay.
Yeah.
Good morning. Are you Justin Leday?
Back to Judge West. The parade of shirts continues.
What is the announcement?
Of course, then she hits the mute button, but yeah, Dairy Queen. Blizzards are good, I guess. All right, back to Judge Fleischer.
Good morning, sir. Sir, you were charged with 2 cases. You're charged with driving while intoxicated, second offense. You're also charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine on each of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Thank you, Your Honor. On April 10th, 2025, officers were dispatched to a motor vehicle crash in Harris County, Texas. An officer already on the scene advised the officer responding that the defendant stated that he had a firearm inside of the vehicle that belonged to him. The officer identified the defendant by his Texas driver's license. The officer observed the defendant to have slurred speech and watery, glassy eyes. The officer observed an odor of alcoholic beverage emitting from the defendant's breath. The defendant consented to perform standard field sobriety tests. The HGN was a 4 out of 6. The walk-in turn was a 3 out of 8. The one-leg stand was a 2 out of 4. And the officer located a handgun inside of the defendant's vehicle during an inventory search of the motor vehicle. The defendant refused to provide breath. A blood warrant was obtained and his blood was drawn.
Okay. Can you tell me when was the first DWI? Number 1, how many DWIs? Number 2, number 3, does he have a valid license, please?
The date of the first DWI, Your Honor?
Correct.
2023, Montgomery County.
Okay. What was it? Well, obviously did some time. Any other DWIs?
No, Your Honor, but if you find it pertinent, a reckless driving from 2019.
Was it pled down?
It's, yeah, convicted on a lesser charge.
So what was the
original?
Right.
Your Honor, I believe the original charge was a driving while intoxicated.
Your Honor, running his license now, they haven't given out cold access yet. It's eligible, Your Honor. Full.
You know what a third DWI is in Texas? A third DWI is a felony offense of the 3rd degree where you're looking at 2 to 10 in the penitentiary. I don't know what is going on with you, Mr. Carrillo, but if I find that you're consuming at all, I'm now placing a restriction on your license. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. On your other ankle, I'm going to put a GPS monitor on you so I know where you are at all times because I don't want you out in the middle of the night. And on your other ankle, you're going to get a scram so I know that you're not consuming. If you have a problem with drugs or alcohol, now is the time for you to take care of it, because if it becomes a problem while you're on bond, I will do it for you and you're not going to like the way that I take care of it. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you use, I will revoke both of your bonds, put you in jail, no more PR bonds. Do you understand?
Yes, sir.
I want you to understand one more thing, that I'm going to do everything in my power to protect my streets at all costs. Watch the news every single day. We have a DWI fatality in our town. It's unacceptable. Do
Yes,
you
sir.
understand?
Yes, sir.
I'm not taking away your privilege to drive, but if I find that you're consuming, it's not going to go well for you. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Pham, and he will tell you if and when you have to come back to court. So for the time being, I don't want you out in the middle of the night. We can talk at a later date if things, okay?
With the court, is you're waiving the fees?
Absolutely.
Thank you.
All right. Good luck to you, sir.
Thank you.
Right this way.
Back to Judge West. Do you know why?
Mr. Vogan, and I will recall that bond forfeiture, and Mr. Lewis, Ms. Vogan's charged with theft of property, and what is the announcement?
Judge, I've gotten an offer from Mr. Nichols on this case. It's Mr. Hoppire's case, so I definitely want to get some mitigation information to him in
Okay.
review, so we can just have a reason to take care of that.
All right, Ms. Vogan, any issues that you see? I'm going to reset your case about 30 days. Make sure you stay in touch with Mr. Lewis so we can see if we can get an announcement, okay?
I don't want to apologize for being late.
That's okay.
The weather,
And Mr. Lewis explained that you called, and so I appreciate that's the most important thing to do is just keep us informed of what's going on. Be careful going back.
All right,
Thank you. What were you saying about Mr. Gilthorpe? I'm sorry. We don't know. Okay.
Oh, Casman. You nailed it. That's spot on. Oh, I love it. Oh, good Lord. Judge Fleischer.
I live, but I ain't been going nowhere. I really ain't got nothing to say.
Okay, so.
It's just, I mean, there.
We're waiting on,
Just bond violation after bond violation. I'm just,
the chief is still in the process on trying to get me that surveillance video, Judge. That specifically allegedly showed the defendant inside of the vehicle, which would constitute a burglary.
let's do this. Let me take a seat for me at the jury box. He's, will you get with him to see what's going on with it?
Yes, sir. Yes, sir, Your Honor.
Yes, Judge.
Ready?
Yes.
Hernandez. Like, oh, well, that's okay.
Page 18, Hernandez.
Good morning, Mr. Hernandez. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 12, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash and made contact with the defendant, who admitted to drinking 2 to 3 beers. The law enforcement officer observed the defendant stumbling and leaning on his vehicle to keep his balance. The defendant stated he did not remember what color the light was when he rolled into the vehicle in front of him. The defendant refused to perform standard field sobriety tests, but consented to a breath test and blew a .211 and a .204.
Ready to be honest?
No, Your Honor. And not in this county. I'm gonna check and make sure.
Nada?
Mr. Hernandez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail. Do you understand?
No prior DWIs, Your Honor.
Okay, does he have a valid license? You mind?
Blaze, can you check the license for me?
Yeah, sorry.
That's all right.
Mr. Hernandez, you are not allowed to drive unless you have a valid license and liability insurance in your name. If you do not have car insurance, you are not allowed to drive as well. And that is a condition of your bond. Do you understand? Darla, do you know if he has a license?
I have made ALR request, but I didn't verify yet. No, Judge.
Sir, I don't have there was no driver's license number in our system.
You know the driver's license number?
Do you have a driver's license?
Yes.
Okay.
I'll let you guys check to see, Darla. I just want to make sure that it's eligible to drive. Otherwise, I'm gonna have him sign an affidavit for it's not to drive. So if you don't mind.
I did find a driver's license number on this, CIC section.
Oh. Joseph, I see your motion. Is that all you got?
Yes, sir.
I'm signing it for you.
Thanks, Judge.
Got it.
I can step back, Judge. We can verify that. And if he does need it, I can then.
Yeah, just let me know.
Signed and everything.
Okay.
Okay, thank you, Judge.
Absolutely, for sure. So for now, you will get with pre-chopper your bond conditions. Don't use. You understand? Okay. All right, thanks, Darla.
Sorry, Aaron.
Got it.
Okay.
All right. Okay. So we'll have.
Judge West again.
I was in the restroom.
Okay. Well, how long have you been in the restroom?
I've been here since before 9.
Your court date your time for
It's
your
at
court
9,
date is
correct?
at 8:30.
Oh, I thought it was 9. My apologies.
So when you get here, you need to take care of your business before it's time for court.
Yes, ma'am.
All right, and this is your initial appearance. I'm going to recall that bond forfeiture. Let me find you on here just a second.
I was having to check stuff for you too.
There it is. All right. So, let's see. Okay, so you were on bond and then come into court, had some resets, and then you were rearrested because the bondsman went off your bond, and then you made another bond. Is that correct? Did you get a lawyer hired?
No, ma'am. But I got the check stubs that I started working. I just started working on my little
Where are you working?
IFL, Indoor Football League.
Mm-hmm.
Even I told you I was going to the UFL.
Yeah.
But other things happened and I wanted to go to the IFL
Okay. Where's that?
in Boston.
In Boston?
Yes, ma'am, correct.
Where's your check stubs? What do you have going on your shirt there?
My bad. I'm sorry.
You think looks probably appropriate for something to wear to court?
I'm sorry. My apologies.
So when did you start?
I started last month, well,
Okay.
beginning of this month.
Yeah. And y'all just get paid, is it every week?
Yes, ma'am.
Once a week?
Yes, ma'am, correct.
Okay. So have you talked to some lawyers?
The one I talked to, but Mr. Rojas, that was my attorney.
Mm-hmm.
And I've been kind of trying to contact him,
Mm-hmm.
but he said once I made the bail, I have to look elsewhere.
You have to try to hire, I mean, you could hire him, you can, just like we've talked about before. You've been given the instructions, you gotta hire a lawyer, or at least try to hire a lawyer. So I want you, I'm gonna reset your case, and the thing is, you're coming back and forth. The sooner you get this taken care of and try to get someone hired, the better. You're gonna have to keep coming back for court dates. So I'm gonna reset your case 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, make sure they get that reset notice that you get today. They'll tell you what to do. If you're unable to, then at least get on the phone, call, make appointments. Some of them will do appointments by phone. Talk to them, see how much they charge, at least 3. Bring me those names when you come back, and then we'll discuss your options, okay? All right, step in front of the clerk. She'll give you that reset notice.
Well, at that point, as many shirts as she's seen, I mean, it started off with Judge Fleischer with the reckless shirt, but then she's just had a parade of people. By this point, she's probably feeling that she's being punked, to be honest. I may try to go through later if I can somehow find the time and at least take screenshots and do a post under the post community tab thing on our channel page, because it's unreal. So real quick in the poll, I need to peace out here in a minute. But in the poll here for Easter, it seems like it's a mixed bag. I was hoping more people would have had a good day, but less than half of you did. As a man of faith, Holy Week's important to me. So overall, it was a good week, though, and a good weekend, though I will tell you the entire time I just have been playing catch up for some reason. I've been running behind for a week now, and I'm still behind today, which is why I can't stick extra long. There's so many things I wanted to do specifically for this channel. I've got some stuff that I'm working on to improve the presentation of the live show, and I just don't have it done yet, and I was hoping to do it this weekend, but you know, one of the traditions here at our house is on Easter Sunday, we actually watch the 10 Commandments, which is like a 4-hour movie. We ran out of time for that. We only got halfway through, so we got to finish that tonight too. But, you know, I got to see a good sunrise yesterday while I was out for my walk, so that was nice. But I hope you had fun today. I did. We had some good laughs, some good time in court, some good interaction in the chat. I hope you all enjoyed it and appreciated it. I'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Please do have yourself a good Monday. Make it a great day however you can. I'll see you all tomorrow. Take care. God bless.